We're back covering the motions in limine. Motion in limine number 10 to preclude evidence and argument concerning retaliation in anticipation of future protected activity. Lively has indicated, including in proposed jury instructions, that she intends to prove defendants took retaliatory actions because they anticipated Lively would engage in protected activity in the future. Evidence of anticipatory retaliatory measures is by definition irrelevant and inadmissible, and should be excluded from all aspects of the upcoming trial. The law recognizes actionable retaliation only in connection with past protected activity, not in connection with future protected activity. One retaliates against something that has already occurred. There cannot be preemptive claim for retaliation because retaliation presupposes a causal connection between an actual and non-contemplated protected activity and an actual and not contemplated adverse employment action. Like in Adams versus New York State Unified, it is well settled that an adverse employment action cannot serve as the basis for a retaliation claim if the action was set in motion before a plaintiff engaged in a protected activity. Quite simply, a person cannot be retaliated against for engaging in protected activity which has not yet taken place. Similarly, since past actions cannot logically be made in retaliation for future protected activity, plaintiff's retaliation claim fails as a matter of law. This well-settled principle applies to retaliation under FIHA, because retaliation under FIHA requires the plaintiff to show that the employer was motivated to retaliate by the plaintiff's protected activity. Actions the employer took before the plaintiff engaged in the protected activity necessarily are irrelevant. And then in McKenna versus Permanente Med Group, dismissing FIHA claim given the absence of a causal connection between protected activity and adverse employment action. It is anticipated that Lively may present evidence and argument that defendants contemplated that she would make protected statements in the future, including statements about allegedly harassing conduct she had endured in the past, and the smear campaign defendants allegedly engaged in was in anticipation of such future statements. Such evidence and argument should be excluded. Totally. Okay, motion in limine number 11 to preclude Lively's prior descriptions of her experience. Yes. Lively includes on her exhibit lists dozens of emails in which she purports to recount to others her objections about her experience on set. And such materials are of limited relevance now that Lively's harassment claims have been dismissed. Moreover, many of these documents were written days or weeks after the alleged events and are therefore not admissible for their truth under any hearsay exception. For example, Lively seeks to offer a blank redacted. Similarly, Lively seeks to offer messages with Jenny Slate dated July 2023 while the set was shut down, as well as testimony from other witnesses reiterating blank. Lively should not be permitted to offer such messages as prior consistent statements unless and until her credibility is attacked at trial, if at all. Rule 801 places strict limits on when prior consistent statements may be offered for their truth, only to rebut a charge of fabrication or to rehabilitate a witness whose credibility has been attacked. The rule does not allow impermissible bolstering of a witness, and the trial court has ample discretion to exclude prior consistent statements that are cumulative amounts of an event. Nor can prior consistent statements be offered simply to rebut only a generalized attack on credibility. This is because, as the venerable Wright and Miller treatise explains, consistency and deceitfulness can coexist. Without such logical connection to the theory of the attack, the probative value of evidence supporting credibility would be insufficient to warrant this consideration. In other words, the prior consistent statement must have some rebuting force beyond the mere fact that the witness has repeated on prior occasion a statement consistent with his trial testimony. To ensure that a prior consistent statement has any meaningful probative value and to ward off improper bolstering, there must be some degree of fit between the attack and prior consistent statement offered to rebut it. But there is no way to determine what statements are consistent with a witness's trial testimony until the witness testifies, and there is similarly no way to determine what statements are necessary to rehabilitate the witness's credibility until specific events are challenged or the witness credibility is attacked. Crucially, some of Lively's allegations are not disputed. For instance, defendants are not denying the contents of the slow dance video Lively makes allegations about, or the comments that were made while filming the onesie scene and captured on video. Thus, it's premature for the court to rule that any of the statements Lively apparently offers as prior consistent statements are admissible as such. Denying motion to admit statements under Rule 801 as premature prior to openings and testimony, and then conditionally granted the government leave to offer prior consistent statements only after the parties had opened, the witness in question testified, defendant attempted to impeach her credibility, and Rule 801 requirements for that specific statement were met. To the extent that defendants do choose to challenge certain aspects of Lively's account as false or exaggerated or otherwise open the door to prior consistent statements, defendants reserve the right to object on the basis that Lively cannot satisfy the other requirements. Motion in limine number 12, to preclude evidence concerning remedial measures taken by defendants. Lively claims she asked for certain remedial measures to be taken and that such measures were taken to address concerns she raised during the first phase of filming. Such measures, according to Lively, include execution of the document entitled Protections for Return to Production, also known as the Contract Writer Agreement or CRA, and the provisions contained therein. Such measures, she claims, also include execution of a nudity rider and the provisions contained therein. Oh, interesting. This is a 17-point contract, I think. Under FRE 407, evidence of measures taken subsequent to an event which, if taken previously, would have made the event less likely to occur, is inadmissible to prove culpable conduct in connection with the event. And then, consistent with this rule, the Second Circuit has held that attempts to use remedial measures as proof of misconduct are highly prejudicial and improper. Under Rule 407, courts routinely exclude evidence of measures implemented in response to allegations of sexual harassment, discrimination, and other civil rights violations. Remedial measures that include policy changes, contractual agreements, and acquiescence of the plaintiff's demands. In the state of Hamilton versus the City of New York, the district court prevented plaintiffs in a Title VII case from introducing evidence that their employer had changed its promotion process to address their concerns of unfairness. The Second Circuit affirmed, holding that it plainly runs afoul of Rule 407 to use such evidence to argue that the earlier process was in fact discriminatory. There are many other similar cases. Similarity of context, the Second Circuit and other circuits had applied Rule 407 to exclude evidence of changes in contractual language when offered to suggest that changes were needed to remedy some defect. The court should therefore prohibit Lively from offering evidence of argument concerning remedial measures for the purpose of proving liability or the existence of some prior wrongdoing. Yes, because the Wayfarer parties, whenever they forcefully agreed to that freaking contract, they were like, but we didn't do these things. And we don't agree with this language. But we agreed that this would protect both parties, so we'll sign it. Anyway, stay tuned for part 6.